Good morning and welcome. I'm Karen Cross, Chief Executive Officer of the Greater Kingston Chamber of Commerce. While no one likes to think about insolvency, it's important to understand how the process works and what options and rights you have as a business owner in the case your business becomes insolvent. Today's presentation will cover and provide an overview of the insolvency and bankruptcy process, as well as commercial proposals, priorities of creditors, the priorities of creditors, implications of bankruptcy, personal asset liability. So no matter the situation you find yourself in, you'll be informed and prepared. Now I'll pass it over to Jessica to say a few words.
Perfect. Well, thank you so much, Karen, and good morning, everyone. My name is Jessica Colvin, and I am the Manager of Business Development and Member Services here at the Chamber. So we're excited to have everyone here today. We've got a great presentation planned for you. Just a couple of things to note before we get started. Today's session is being recorded and will be available on our YouTube channel later this afternoon. We've also allotted some time for Q&A at the end of the session, but encourage you to enter your questions in the chat box as we go along. We are proud to partner once again with the Pro Bono Student Council, Queen's University chapter, to provide law students with rewarding opportunities to volunteer on projects that align with their skills, experience, and education, all with the aim of promoting greater access to justice in our community. Now, I would like to pass things over to Dylan Ricci, JD candidate, Queen's University, Faculty of Law, to begin today's presentation.
Thank you, Jessica. I just share my screen here quickly. Perfect. Can we all see the slides here? Perfect. Alrighty, and with that, I'll get our presentation started. Good morning, everyone. My name is Dylan Ricci, and along with my colleagues Warren, Theodora, Sam, and Justin, we are going to be talking about the bankruptcy process for small businesses. All of us are Queen's Law students, and over the course of this academic year, we have researched and are presenting our findings on the insolvency process and how it relates to small businesses. Just a brief disclaimer here, we are not lawyers, and nothing in this presentation should be taken as legal advice or relied upon as legal advice. So for our agenda today, we'll be talking about insolvency in the bankruptcy process, proposals and receivership, the priority of creditors, the implications of bankruptcy, and when creditors can go after personal assets of an individual when a business goes bankrupt. On that note, I'll be passing up to Warren so that he can talk about the insolvency and bankruptcy process.
Thank you, Dylan. So the goal of our presentation is to provide Kingston businesses with some context on how the future looks in terms of the fiscal landscape in Ontario and the legal impacts of business closure. Of course, we want to see our local businesses succeed and avoid going into debt, but we also want to be realistic and provide helpful advice during this uncertain climate where bankruptcy might be more likely for certain businesses. So the Financial Accountability Office of Ontario reported in April of this past year that insolvencies actually dropped in Ontario by 24% despite the pandemic. This was particularly unusual for a recessionary period because it can, but it can likely be explained by the high levels of government aid, low interest rates, and lender payment deferrals that kept some businesses from declaring bankruptcy. But despite the short-term decrease in businesses becoming insolvent, the FAO warned in their report that insolvencies could increase this year due to the ongoing economic challenges associated with the pandemic, as well as government withdrawal of their financial support to small businesses. Additionally, the report suggests that interest rates are expected to rise gradually, which will put greater pressure on debt obligations for Ontario businesses, especially those businesses that entered the pandemic with some moderate debt already. So with this uncertain backdrop in mind, we're going to explain what options businesses have when they're faced with hard financial times. Now, although this portion of the presentation is going to be about the options businesses have once they enter that sort of death spiral of bankruptcy, later on, Justin will be discussing other legal options like the creation of a forbearance agreement that businesses can try to create with their lenders to avoid the bankruptcy process altogether. So we're going to be running through an example situation with our model company, Dunder Mifflin. So this complicated scenario of insolvency and bankruptcy becomes a bit more clear and relatable. In recent times, since COVID-19 struck the Scranton, Pennsylvania region, Dunder Mifflin's financial health has hit a wall. Dunder Mifflin has been accruing large amounts of debt from unpaid rent for their office space, unpaid supply contracts for their paper products, and unpaid employee wages. The total outstanding value of the unpaid debt of Dunder Mifflin is more than $1,000. So this means that Dunder Mifflin is currently unable to meet their financial obligations to their creditors. The landlord, the paper supply company, and employees who are all owed money from Dunder Mifflin are what's called creditors. Under the relevant statute, which is called the Bankruptcy and Insolvency Act, or BIA for short, Dunder Mifflin has met the test of what constitutes an insolvent corporation. Now, for a corporation to be insolvent, the amount of money owed to creditors must be at least $1,000 in total, and the company must be they must meet one of only the following three requirements. So either they cannot meet their financial obligations when they become due, such as paying rent on the first of the month. They've stopped paying their current financial obligations in the ordinary course of business as they become due, or the combination of the company's current property, if sold at a fair market value, would not cover all the debts owed to creditors. So, for example, Dunder Mifflin may have some assets that are valuable, such as forklifts, industrial printers, and those could be sold on the market for a total of $30,000. But if that $30,000 can't cover their debts owed to creditors, Dunder Mifflin would meet this last requirement for insolvency. So after becoming insolvent, Dunder Mifflin, like other small businesses, have three main options. I'll touch on the two options related to bankruptcy, and Justin will talk about the options to create a commercial proposal next. So we know that a debtor is an insolvent person who is unable to pay their debts when they become due, and the debts owed have to be at least $1,000. A corporation or individual changes from an insolvent debtor to a bankrupt debtor when the insolvent debtor has filed for bankruptcy themselves or have been put into bankruptcy by the individuals who are owed money, so those creditors. Bankruptcy is a legal process that allows the business to get rid of its debts, sell off its assets, and make sure that the company's creditors are given their fair share. At the end of the bankruptcy process, the bankrupt debtor is released from the obligation to repay the debts they had when the bankruptcy was filed, with some small exceptions. More often than not, the operations of a business stop at the date of bankruptcy. This is one of the reasons why declaring bankruptcy is obviously a challenging process for business owners who want to avoid having to shut down their operations for good. So the first option Dunder Mifflin has once becoming insolvent is to voluntarily enter bankruptcy. When a business voluntarily declares bankruptcy, this process is generally called voluntary assignment. And an assignment into bankruptcy happens when a debtor voluntarily assigns all their property to what's called a licensed insolvency trustee, or LIT for short. In our office scenario, Michael Scott would meet with a licensed insolvency trustee who would evaluate the business's assets, debts, and current revenue streams. A LIT takes the debtor's property so it can be sold or used to pay off debt. So, for example, Dunder Mifflin might have some valuable office machinery that could be sold to the sold by the trustee to help reduce its debts to their outstanding creditors. The voluntary bankruptcy process avoids a court proceeding, and your licensed insolvency trustee will handle the filing of paperwork with the relevant federal government office. And this option might be the right choice for some businesses, since a business receives immediate protection from creditors, which means that the creditors can no longer start or continue legal proceedings against the debtor without a court's approval. So for a creditor to actually participate in the distribution of assets of the bankrupt estate, they have to file what's called a proof of claim. The three conditions for provable claim are seen on this slide. However, having a provable claim is not necessarily a good thing for these creditors. The creditor's claim will usually be dismissed once the debtor is discharged from the bankruptcy process. If the debtor has very few assets, the creditor is actually better off with a non-provable claim. This is because a creditor can enforce its claim against future post-discharge assets of the debtor, since the non-provable claim isn't dismissed when the debtor receives a bankruptcy discharge. The situation is actually different if the bankrupt is a corporation. Unless all creditors claims are settled, bankruptcy signals the end of the business operation. Without a provable claim, a creditor will receive nothing. The second route to bankruptcy is involuntary. So in this situation, a creditor files a bankruptcy application in court against the debtor. For example, the landlord of the Dunder Mifflin office could petition the business into bankruptcy if they think that they will not be paid if bankruptcy proceedings don't take place. This form of bankruptcy is relatively rare. If a debtor has committed an act of bankruptcy, a creditor can go to court and ask the court to force the debtor into bankruptcy. Under Section 43(1) of the BIA, a creditor can only file an application against the debtor if the debts owed to the creditor are at least $1,000 or more, and the debtor has to have committed one of 10 acts of bankruptcy within the last 6 months of the application. Generally, these acts would often be something like, ceasing to pay debts when they become due, or providing statements to creditors that your business is insolvent and you no longer can pay off debt. Even if the creditor has the ability to make an application to the court to start this involuntary bankruptcy process against Dunder Mifflin, it doesn't necessarily mean that they will. There are significant legal costs associated with making an application to the court, and a creditor has to be owed a substantial amount of money for this option to even be worthwhile. For these reasons, it's quite unlikely that Dunder Mifflin would be forced into bankruptcy by a landlord who is just short a few months of rent. If Dunder Mifflin doesn't want to voluntarily declare bankruptcy, and it's unlikely that one of their creditors would submit an application to the court to put them into bankruptcy, what other options does Dunder Mifflin have? A third option a business like Dunder Mifflin has is to file what's called a commercial proposal through their licensed insolvency trustee. This choice seems to be a good option for Dunder Mifflin since the business only has a few debts to pay off, and Michael Scott wants to continue running the business's operations. Justin will take it from here to explain the commercial proposal option.
Great, thanks, Warren. So to start off, what exactly is a commercial proposal? When a small business is insolvent, they're able to file a commercial proposal. They're filed with the help of an individual called a licensed insolvency trustee, or like Warren said, a LIT, who oversees and administrates most of this process. Through filing a commercial proposal, what a business is doing is they're asking creditors to not insist on the exact terms of their original agreements so that the business might still survive. The proposal acts to stop all legal actions that are undertaken or contemplated by secured and unsecured creditors. There are two ways that creditors can provide breathing space in response to a proposal. The first is that the creditors can give up rights to amounts that they are owed. For example, instead of being paid the full $100,000 loan that's outstanding, the proposal could suggest a certain number of cents on the dollar, for example, 50 cents, so they only owe $50,000. The second way is that the business can ask creditors for a grace period during which it makes no payments. This may allow the business to get back on track, at which point they would be able to pay back 100% of what is owed to the creditor. So you might be thinking, this seems pretty great for the business, so why exactly would a creditor agree to this? If the business falls into bankruptcy, depending on the priority of various creditors, which we'll discuss in the next part of the presentation, the creditor risks receiving none of what is owed. However, if the business is able to survive, the creditor can recoup some of what is owed and potentially retain the business as a client, leading to the possibility of future profitable ventures. Once the commercial proposal has been filed, the creditors meet to consider it. They vote, and it must be approved based on obtaining 1, a majority of the creditors involved, and 2, a majority of the dollars that have been loaned. If the creditors accept the proposal, it must then be approved by the court. But if the proposal is rejected, the business is immediately declared bankrupt from the date of the creditors' meetings, and the creditors can continue or begin any legal actions to collect the amounts that are owed. This point is key because you're not bankrupt as a business when you file the commercial proposal. It is only if you are rejected that you're deemed to be bankrupt. And once the proposal has been filed, it cannot be withdrawn until the creditors and the court have rendered their decision. So some noted advantages of the commercial proposal are that 1, actions against the business are put on hold. 2, businesses can solve financial problems without declaring bankruptcy. 3, unsecured debts are paid off at only a portion of the original amount. Secured creditors cannot enforce their security agreements until the proposal is voted upon, so they can't seize and sell any collateral. Actions against directors will be put on hold unless the director has provided a guarantee on the loans. And finally, tax debts can often also be paid off at a portion of the original amount. Now, there is one potential alternative to commercial proposal, and that is called a forbearance agreement, which we'll go over quickly here. So this is a contract that's entered into between an existing lender and a borrower. The lender, sort of like a commercial proposal, agrees to refrain from enforcing certain rights, and in return, the borrower makes certain concessions with respect to the terms of the agreement. Now, what purpose does this serve? 1, it provides the borrower with more time. The parties can avoid costly and uncertain litigation, which is pretty common with bankruptcy procedures. The lender can reassess the finances of the borrower and the likelihood of repayment. And the lender can also perfect securities by making a new forbearance agreement. But they don't come without risks. If there are multiple lenders and you're at risk of default on more than one debt, you would have to enter a forbearance agreement with each of those lenders. Some may agree to it and some may not, at which point it might just be easier to do a commercial proposal. They're also legally complicated, as you will require legal advice to ensure that the forbearance is valid. Finally, you can't include something in the forbearance agreement that would give preference over third-party creditors. This is a good legal option, but of course, before this, you're always looking to cut expenses and take other non-legal options first. So, bad news, the paper market has completely dried up and Dunder Mifflin has found itself facing bankruptcy. What are the next steps? First, we're going to go over the bankruptcy process. So our first step is, together with the licensed insolvency trustee or LIT, Dunder Mifflin must file their documents with the Office of the Superintendent of Bankruptcy. Once these documents are filed, the company will formally be declared to be bankrupt. The LIT will then take over dealing with Dunder Mifflin's creditors on their behalf. At this time, payment to unsecured creditors stop, any garnishments against salaries stop, lawsuits that are launched by creditors stop, and all of Dunder Mifflin's creditors will also be notified about their bankruptcy. The LIT will begin to liquidate or sell Dunder Mifflin's assets. This money will be held for distribution to creditors. So there's 2 distinctions here. If Dunder Mifflin is a sole proprietorship or a partnership, this is treated like a personal bankruptcy. The assets and debts of the business are seen as the owner's. The owner's assets can be liquidated and sold as a result. But if Dunder Mifflin is incorporated, the owner is often protected from liability, which keeps their personal assets from being at risk unless they've been put up as collateral for debt. At this time, creditors may hold a meeting to obtain further information. If this happens, the bankrupt party must attend. There are some ongoing obligations during the process. So first, the bankrupt party must submit copies of pay stubs and proof of other income to the LIT every month. And they also must pay the fees for the licensed insolvency trustee for the work that they are doing. Now, if all goes well, Dunder Mifflin will be discharged from bankruptcy. What a discharge does is it releases the debtor from legal obligation to repay the debts that they had as of the date of filing for bankruptcy. There are 3 types of discharge: absolute, conditional, and suspended, which Sam will walk you through later in this presentation. Our next topic to discuss is receivership. So receivership is a form of liquidation. To be more specific, it is a remedy that is available to secured creditors to recover amounts that are outstanding in the event that a company defaults on its loan payments. What the receiver does is they take possession of and sell the assets that are secured by the loan agreement. The proceeds from the sale are often used to pay the money owed to the creditor. So, for example, if Dunder Mifflin put up an office building as collateral, the receiver takes possession of and sells that property in order to satisfy the outstanding balance of the loan. An important distinction to make is that this is not the same thing as bankruptcy. You can go into receivership without being bankrupt. So, for example, by defaulting on just one of 3 loans. And you can also go into receivership at the same time as bankruptcy. Typically, receivership is less expensive and can be preferable. It requires fewer hearings, filing requirements, and fees, so the parties tend to face lower costs and expenses. The receiver can be appointed by the secured creditor or by the court, but they must be a licensed insolvency trustee. If the receiver is privately appointed by the creditor, they are responsible primarily to the creditor that appointed them. However, court-appointed receivers will act on behalf of all creditors. Next, we'll discuss the steps that are in the receivership process. So first, the secured creditor would make an application to the court. The court uses its discretion to appoint a receiver. The scope of the receivership could be as broad or as narrow as the court decides is appropriate. And once that's done, the receiver is typically granted the following powers. One, they're given possession and control of the assets of the debtor. And two, they're given the power to manage the business of the debtor and to dispose of those assets. The receivership order also usually contains a stay of proceedings. So like the commercial proposal earlier, any legal actions are stopped. Commonly, the receiver will be directed by the court to conduct an orderly sale process before applying to the court for two things: approval of any sale and for an order that vests title in the assets in the purchaser. So the assets are no longer considered to be part of any loans as collateral, they belong to the new purchaser at that point. The court will determine how the proceeds of the receiver's sales will be distributed to creditors in accordance with the relative priority of their claims. And on that note, Taylor will talk about the distinction between and implications surrounding secured and unsecured creditors.
Thanks, Justin. So the Bankruptcy and Insolvency Act relies on the distinction between secured and unsecured creditors to determine how priority is assigned to creditors. First, a secured creditor is any one individual or institution that has lent money to the company, in our example, Dunder Mifflin, and obtained security in exchange for that loan. For an individual to be considered a secured creditor, they have to hold a mortgage or a lien, for example, against Dunder Mifflin's property or any part of that property as security for the debt that they are owed. Creditors generally register their financing statements under the Personal Property Security Act, also known as the PPSA. Otherwise, the security could be held contractually under a security agreement made between secured creditor and Dunder Mifflin. Since secured creditors have a proprietary interest in Dunder Mifflin's property, the secured creditor can take action to get their money back first if Dunder Mifflin begins to miss payments or declares bankruptcy. Next, we have unsecured creditors. This is an individual or an institution that's lent money to Dunder Mifflin, but didn't receive any specific asset as security. It's a risky move for creditors to be unsecured since they'll have nothing to fall back on if Dunder Mifflin defaults on payments or becomes bankrupt. The unsecured creditors have no proprietary claims against Dunder Mifflin's assets, which puts them at the end of the queue when trying to recover their loans. Some examples of this can include credit card debt that Dunder Mifflin may have, any unsecured bank loans, or even monthly utility bills. An important point to note is that if Dunder Mifflin decides to transfer property or make payments to a creditor with whom they're dealing at arm's length, it'll be deemed void if the transfer is made within 3 months prior to them declaring bankruptcy. So an implication of this is that if Dunder Mifflin owes money to creditors and is at risk of becoming bankrupt, any attempt to pay out one creditor to whom they give preference over another isn't going to work. Giving a creditor preference will be deemed fraudulent and void if Dunder Mifflin goes bankrupt within 3 months. Similarly, if Dunder Mifflin attempts to make payments to a person related to the insolvent business, so a family member, the period increases from 3 months to 12 months. Lastly, we have preferred creditors who are still unsecured creditors, but they are given some priority in bankruptcy. Once Dunder Mifflin has declared bankruptcy, and each class of preferred creditors has to get their share back from the sale of Dunder Mifflin's assets. For example, employees and any wages owed to them can fall into a class of preferred creditors. When Dunder Mifflin declares bankruptcy and ceases operations, it's unlikely that it'll need to pay its employees severance. So in order to get severance, a few criteria must be met by both the employee and the employer. First, the employee must have worked for Dunder Mifflin for at least 5 years. Second, Dunder Mifflin's payroll must be $2.5 million or more. And third, Dunder Mifflin must have terminated the employment of 50 or more employees within a 6-month period. If there are multiple claimants in one class, so multiple employees, for example, creditors will receive payment on a pro rata basis. So what that means is that any remaining proceeds will get divided between these creditors proportional to how much is still owed to them. In the event that Dunder Mifflin's employees are owed wages, what are their options to recover those wages? The Ministry of Labor Training and Skills Development is limiting the actions it can take against employers under the Employment Standards Act to recover wages. Employees would receive a package from the trustee or receiver containing information on what steps will need to be taken to file a proof of claim with the trustee or receiver. In some cases, directors of the bankrupt company could themselves be held liable for unpaid wages, but not for unpaid termination or severance pay, so only unpaid wages. The amount that must be paid to employees is the amount of wages owed to them, up to a maximum amount of 7 times their weekly insurable earnings under the ESA, the Employment Standards Act, minus any amount prescribed by regulation. In the case that Dunder Mifflin is both bankrupt and subject to receivership, the amount that they will have to pay to former employees is whatever the greater amount is determined in respect to the bankruptcy and the amount determined in respect of receivership. So whichever one comes out to be higher. Another option that employees have to recover wages is through the Wage Earner Protection Program, the WEPP. Its purpose is to make payments to employees in respect of wages owed to them by the company, Dunder Mifflin, who can either be bankrupt or subject to receivership. A trustee will be named to handle the employee's files, and employees willing to file a proof of claim with the trustee or receiver, my apologies. An employee would only be able to make a claim under the WEPP if 3 things. 1, the employee retired, resigned, or was terminated, or the term of employment expired. 2, if Dunder Mifflin is in bankruptcy or subject to receivership. And 3, if the individual is owed eligible wages by the former employer. The amounts covered by the WEPP are as follows. Any unpaid wages in the 6 months prior to Dunder Mifflin declaring bankruptcy or receivership, termination or severance pay up to $3,000, and an amount equal to 4 times the weekly insurable earnings under the Employment Insurance Act. And finally, to get a nice overview, the priority of all creditors will be as follows. At the top of the list, we have secured creditors. So as mentioned, these are various types of secured creditors, and they are ranked differently in the hierarchy based on the nature of the debts or assets. A secured creditor collecting debt for a mortgage loan over land, for example, will take priority when it comes to getting profits from the sale of Dunder Mifflin's land. Second, in the event that the bankrupt individual is deceased, in our case here, Dunder Mifflin cannot be deceased in the same way that a person would, but if the bankruptee were an individual, that any funeral or testamentary expenses will be paid next in the hierarchy. In third place, we have a general admin cost, like any legal fees, lit fees. In fourth place, any dividend taxes will be paid to secured, preferred, and unsecured creditors. So these taxes could include levy payable to the Office of the Superintendent of Bankruptcy, who regulates the insolvency industry within Canada, for example. In fifth place, we have preferred creditors. As mentioned previously, this could include specific types of employee claims, child or spousal support claims, municipal taxes, landlord claims, and so on. And in last place, we have unsecured creditors who will get repaid on a pro rata basis. So as mentioned, any remaining proceeds get divided between unsecured creditors based on how much is owed to each one. So it's proportional to what they're still owed. Now I will pass on to Sam.
Thank you, Tio. So I will be talking about the various implications of bankruptcy. Now, as you know, bankruptcy is a difficult position to be in, and there are various implications. A person who declares bankruptcy will get the lowest possible credit score. Equifax uses a rating of R1 to an R9 scale, with a perfect credit being displayed as an R1 and bankruptcy being displayed as an R9. A low credit score can jeopardize a person's ability to obtain student loans, mortgages, lines of credit, employment, or registering for subsequent credit cards. In addition, insurance companies may even charge you higher premiums if you have a poor credit score. During your first bankruptcy, your low credit score will be cleared after 6 to 7 years, but any subsequent bankruptcies, that low credit score will take about 14 years to be cleared. In the next slide, I have a picture showing the various credit scores and the range of whether they're good or bad. Fortunately, most Canadians have a good credit score, which is anything in the green. When I've talked to my realtor colleagues, they mentioned that in order to rent an apartment in Ontario, you need a credit score that is ideally above 620. Another big implications of bankruptcy is the liquidation of your assets. So various assets can be liquidated, which include your properties, such as your house and your car. There's also spousal interest that can be liquidated. Now, don't worry, no one's going to go after your spouse, but but any debts that you have with your spouse for joint assets, they can be taken proportionally by the creditors. But they can't go after the debts that are solely owned by your spouse, only the debts that you own yourself or any joint debts that you own with your spouse. And there's also the co-signers of loans. Anyone who co-signed the loan for you will still be responsible for making the loan payments after you go bankrupt. So your co-signers, whether that be your parents, friends, they will also be responsible for the debts that you owe. Wages are not affected by bankruptcy. Once an individual or corporation files for bankruptcy, the wage garnishment will immediately stop. And when it comes to the issue of student loan debt, a discharge from bankruptcy will release you from your obligation to repay your student loans if you file for bankruptcy at least 7 years after you stop being a part-time or full-time student. If you're going to file for a bankruptcy before 7 years, then you can also have some sort of negotiation to say that you've had a lot of undue hardship and you've made efforts to repay your debts. In that case, there will be some flexibility. With regards to the discharges of bankruptcy, a bankrupt individual may get discharged, which is a legal prohibition against creditors from starting or continuing to go after their payments from the bankrupt individual. Once you receive your discharge, you're released from the debts covered by your bankruptcy. In almost all cases of bankruptcy in Canada ends in automatic discharge. There are 3 different types of discharges that can occur. One is an absolute discharge. This is when you're officially released from all the debts before you declared bankruptcy, so you're completely off the hook. And then there's a conditional discharge. This is a set of court order conditions that must be met before your bankruptcy discharge becomes absolute. For example, the court may require you to pay additional payments for the distribution of some of your creditors. And then there's also a suspended discharge. This is an absolute discharge that will not be effective until a certain date. The court may order a delay pending on the outcome of criminal investigation or a breach of your duties as specified in the Bankruptcy and Insolvency Act or due to a prior bankruptcy. And then in a very rare instances, there could be a refused discharge, whereby the courts refuse to give you any kind of discharge and you might continue having to pay your debts, but this is extremely rare. There are some exceptions to discharges. These include things such as paying support payments to a former spouse or to children. There could be fines for monetary penalties imposed by the court that you will still have to pay. There may be debts that you owe from fraud, or student loans after fewer than 7 years have passed since the bankrupt stopped being a full or part-time student. It is important to note that there is a limited debt collection period. A creditor has a limited time to collect their debt. If the creditor doesn't file a court action within the statute of limitation period, which is 2 years in Ontario, then it loses the right to raise the action. The limitation period starts over as if you as a debtor make even a partial payment towards the debt. But even if the 2-year period passes and the creditor makes no claims, your credit report will still be negatively impacted, even though no bankruptcy proceedings are actually initiated. Certain debts like taxes, government guaranteed student loans, and debts for child support are not subject to the same 2-year limitation period. Now, filing for bankruptcy can immediately stop the demands from creditors. It puts an end to those demanding phone calls and emails that you receive, and it stops any action taken by lawyers against you, and they will all be halted. Just because a creditor can't sue you, that does not mean that collection calls will stop. Old debts are often resold, and these agencies will continue to call to see if they can collect even a small amount from you to settle the debt. It's important to note that there are certain types of conduct that a debt collector can and cannot do. I will be discussing about what the debt collector can't do. For instance, they can't suggest to your friends, employer, relatives, or neighbors that they should pay your debts unless one of these individuals has co-signed a loan. They can't use threatening or intimidating or abusive language. They can't apply excessive or unreasonable pressure on you to repay the debt. They can't misrepresent the situation or give false or misleading information. They can't call you on your cell phone unless if you provided that number as a way to reach you. A debt collection agency can't add any collection-related costs to the amount you owe other than your legal fees or fees for non-sufficient funds on payments that you submitted. For example, a debt collector can't charge you for the cost of moving your assets from your house to another location. If in the event that when you're filing a complaint with a collection agency, you find poor service or unprofessional conduct, you can file a complaint with the general regulator in Canada, which is the Financial Consumer Agency of Canada. If your creditor sold your debt to a collection agency and you want to make a complaint about the agency's debt collection practices, you can file a complaint with Consumer Protection of Ontario, and there's different offices for every province with regards to filing the complaints in this manner. Now I will pass it on to Dylan.
Thanks, Sam. So for the last part of this presentation, we're going to be talking about personal assets and when creditors can go after them in the context of a business. So the first question we have to ask is, can creditors go after personal assets? Well, the answer to this question is the classic legal answer of it depends. This is because your personal liability for the business is going to depend upon how your business is structured legally. Generally, there are three common ways that businesses are structured. So they're either structured, well, there are other ways, but the three main common ones are, it's either a sole proprietorship, a partnership, or a corporation. So for a sole proprietor, it is owned and operated by an individual and not considered a separate legal entity. And in this situation, personal debt incurred by an owner could be claimed against the assets of the business. So for instance, let's say we have Michael Scott, who runs, who is a sole proprietor and he operates Dunder Mifflin. And in his free time, he promises to pay for the tuition for a group of disadvantaged youth if they get accepted to a certain college. But he never ends up paying them, and the youth who are owed money, they could potentially go after his personal assets and also the business assets of Dunder Mifflin in that scenario. That is because with a sole proprietorship, there is no real distinction between business assets and personal assets. Business creditors, however, do have the right of way over personal creditors. So if the individual does go bankrupt, the business creditors would have a right of way over the assets of the sole proprietor over the personal creditors. Some personal assets are exempt when under a certain value as highlighted under the Execution Act of Ontario. And so what it says in the Execution Act of Ontario is that some assets of an individual that is not a corporation are exempt from forced seizure or sale by law when under a certain value. So, and these are listed as below. So necessary clothing cannot be seized or taken. And so certain household furnishing and appliances when it's below $14,180. Tools and other personal property of the debtor when it's below $14,405, and then one motor vehicle of $7,117. So just provide an example of one of these categories is, let's just say, you have Micah Scott has a 2007 Toyota Camry that most likely would not be able to be seized by the creditors. However, if he has more than two vehicles, or he has, a really, be it a brand new Mercedes, Michael Scott, that his Mercedes could most likely be seized in this scenario. Also, if you have a principal residence that's under $10,783, that would also be exempt from it. And so for their next category is a partnership, and the partnership has a really what's mine is yours attitude of a partnership. So generally speaking, the personal and business's assets are available to a creditor when you're in a partnership. And that's generally speaking for both partners or however partners there may be. However, something that is important to keep in mind here is that it is only creditors that are related to the businesses of the partnerships. So for example, if Jim Halpert and Michael Scott are partners of Dunder Mifflin, and the youth that Michael Scott owes tuition to, tries to go after Jim Halpert's personal assets, they would not be able to do it in this case because that wasn't a credit or a debt or liability, pursued in the course of their Dunder Mifflin business. And then we have an example, we have a type of partnership called limited liability partnerships. And the way limited liability partnerships work is that they are only liable for the debts to the amount that they've invested into the partnership. So what this means is that if you put $100,000 to $100,000 into a partnership, and then you go bankrupt and they're looking to seize assets, they can only seize for the amount of money that you put into the partnership. So if you put in 100,000, you'd only be liable for the 100,000 that you put in and nothing more, and no more personal assets. However, it's important to realize that with a limited liability partnership, this exemption is nullified when a limited partner plays a role in the management of the business. So if you have a limited partner who's more of a passive investor, they'd be fine. But once the limited partner starts to play a more active role, and they start to play more in the management decisions, they'll be seen as a general partner, and they'll be liable to both, the personal assets and the business assets. They'll be liable in the case of bankruptcy. And then last but not least is if you have a corporation. If your business is a corporation, it is most likely that creditors cannot go after your personal assets. This is because the corporations are generally seen as a separate legal entity or a legal person under the law. So this means that corporations generally have the same rights and obligations as an individual. So the corporations own the assets and own the assets of the business, and these assets are separate from the personal assets of the directors or the shareholders. So this is where the corporations benefit from this limited liability aspect of their structure. However, certain exceptions apply, and directors and shareholders can sometimes be held personally liable for corporate debts. So exceptions to corporate limited liability are if the debt is signed by a guarantor. So if you have a director or shareholder that signed a debt for the corporation, in this case, that's giving your personal guarantee. And if the corporation defaults on the loan, the creditor can go after that individual for that money because you've signed it as a guarantee, and thus you are liable in the case of default. And then directors can also be liable for certain unpaid taxes or expenses. So if your corporation owns money to the government and the corporation refuses to pay it, the government can go after the personal assets of the directors of the corporation in order to recoup some of their money. And then last but not least, we have what are called impeaching pre-bankruptcy transactions. So what is happening with this is that the idea here is to stop transactions or allow debtors to avoid paying creditors by transferring property to a third party. So under the BIA, there are 4 ways to impeach a pre-bankruptcy transaction. It's either a transfer under value, a preference, a post-initiation transfer, or a distribution to a shareholder. So with a transfer at undervalue, what you have is that is when a corporation transfers or sells an asset for way less than fair market value for what it's worth to another individual. So, you give it as a gift, to a close relative or something like that, or you sell it for way less than what it's actually worth. This is an example of a transaction that can be seen as void, and the creditors could go after the asset that was transferred from the corporation to the individual. So this is an example of where you can actually be, where an individual can be held, liable for in the situation of a corporation's bankruptcy proceedings. And then there's another thing called a preference. So this is what happens this is when essentially the corporation that is debtor, they transfer a property to a creditor. This would be kind of seen as giving a preference to a creditor and thus really lowering the pool of assets that are available to the whole pool of creditors. And in that sense, they'll try to essentially claw back that transaction or get those assets back from the individual to the corporation in order to ensure that all creditors get a fair share of the assets of the business. And then there's another thing called a post-initiation transfer. So when the creditors initiate the bankruptcy proceedings, essentially every transaction by the corporation can be impeached, essentially. However, something important to keep in mind is that there are a large amount of exceptions to this. So for instance, if it's a payment to a creditor, then that's fine. If it's a payment or a delivery to the bankrupt, then that's also exempt. A transfer of fair market value by the debtor would also be exempt from this, and then the contract has adequate consideration. So it seems kind of broad, but it's really narrow when you look at those exceptions in that. And then last is a distribution to shareholders. So giving a dividend to your shareholders, they can find the directors of the corporations personally liable for the amount of dividends given to that shareholder. However, in order for this to work, there needs to be certain elements need to be required. The corporation has to be insolvent, and the directors cannot reasonably believe, that the corporation was solvent, and then the dividend occurred within a 1-year period before the initial bankruptcy event. So an example of this is if Michael Scott is a sole shareholder, director, and officer of Dunder Mifflin, and while he knows Dunder Mifflin is insolvent, and in the year before that the bankruptcy proceedings, he gives a massive dividend to himself, the creditors can go after the personal assets of Michael Scott for the amount of the dividend that he gave. So an example of this, these are all kind of I would describe them as anti-circumvention measures where it is possible that directors or people associated with the business, the bankruptcy proceedings can go after their personal assets. And so, subject to any questions you may have, that is the conclusion of our presentation. Also, just a brief thing I would like to bring up is that, if you ever have need advice for a specific legal situation you're in when it comes to insolvency, we highly recommend you guys use some of the Queen's Law clinics at our offers. So there's Queen's Legal Aid, and then there's the Queen's Business Law clinics. They can generally help out with with more complicated situations. So if you guys have any questions, that is the end of our presentation.
Perfect. Well, thank you guys so much for speaking with our membership today. We're really grateful for all the time and effort that you guys took to share your research and your thoughts with us. And personally, I really appreciated all the office references that made it very enjoyable too. So now we'll be opening the floor to anyone that has a question. I would just ask yourself to either unmute yourself or you can type it into the group chat. We do have one question to start us off. Thank you, Mark, for submitting that. So the first question is, where would a creditor stand if we sign a personal guarantee, in this case with a bank? Does anyone feel comfortable tackling that?
Yeah, so I can try to address a little bit. Thanks, Mark, for your question. I'm going to assume that the personal guarantee was signed in respect of a business loan. So in this case, the bank is a secured creditor. However, in terms of implications, I will unfortunately have to respond with the usual, it depends. It depends on what was written in the agreement, in the guarantee, but it could mean that you may lose whatever assets or assets you put up as collateral.
Perfect. Thank you so much for that, Mark. I hope that answered your question. I'm just scanning here to see if we've got anyone with their hand up at all. Now, I will say, I know that this is being recorded. So if you have a question that you would prefer to ask offline, that's totally fine. Feel free to send me an email after the call, and we'd be happy to pass it off to the speakers today. All right, you guys might be lucky. It looks like we've got a quiet group today, possibly because you've covered everything that they needed to know in today's presentation.
Yeah, let's hope that's the reason.
Yeah.
We have those resources at the end of the slide deck too. And all those Queen's legal clinics are super helpful and free to use. So I would definitely leverage those as well. Perfect. All righty. Well, I think in that case, if no one has any other questions, we can wrap up a couple minutes early. Thank you again to all of our presenters, and especially thank you to all those who joined us today. We hope to see you next week at our next event, our annual general meeting that's happening Tuesday, April 5th at the Delta. So thanks everyone again, and enjoy the rest of your day.